This is Colin O'Keefe here for LXBN TV. President Obama recently signed an executive order barring federal contractors from discriminating on the basis of gender orientation and sexual identity. Joining me now to share his thoughts on the executive order is attorney Richard Cohen. He's with Rothschild and author on the Employment Discrimination Report. Richard, first off, can you walk us through this executive order? Just how far is its reach here?
Surely. An executive order is unlike a statute. A statute passed by Congress, signed by the president, such as Title VII, can apply to businesses, interstate commerce, pretty much any business in the United States. An executive order is an order of the president, which he's entitled to do, which will only apply in limited circumstances. There's a lot of ferment going on now about the power of the president to do that, but he can do it with respect to federal contractors and federal agencies, which is relevant here. But in this particular case, President Obama decided to try to at least do a little more than Title VII has done. Title VII prevents discrimination in the workplace with respect to race, creed, religion, etc. It doesn't prevent discrimination on the basis of sexual orientation or gender identity. Unlike, let's say, New York City or New York State, which does prevent that, Title VII nationally does not. So President Obama issued an executive order which covers both federal contractors and federal agencies and requires that both of them now cannot discriminate on the basis of someone's sexual orientation or gender identity.
I see. And then recently, of course, we had the Hobby Lobby ruling come out of the Supreme Court. And of course, the justices tried to keep that decision as narrow as possible. But still, we've already heard about plenty of challenges on the basis of it. And many people have a great deal of concern for its potential reach. So let me ask, is this an area or a situation where that Hobby Lobby decision could potentially apply?
Absolutely. Irrespective of whether it should apply or not legally, it's anticipated that the faith-based community, at least the more extreme religious groups, are going to attack this particular executive order under Hobby Lobby, claiming that their religious rights are being infringed by having to hire people, lesbians, gays, etc., or people with different gender identities. In this case, President Obama redemption for them under the executive order, and they've already announced that they're going to attack it in the courts.
I see. It's going to be interesting to see what the effect is there, but let me actually ask, what is the likelihood of success for challenges like that?
Well, I would suggest that it's not likely. In this case, the majority decision in Hobby Lobby, written by Justice Alito, he made it clear that this was a very narrow decision. It shouldn't be applied in other situations. But of course, I predicted a Hobby Lobby would go the other way also. So it's hard to say with the Supreme Court. It's so fractured. It sort of reflects the nature of our society now. It can go either way. With this 5-4 type of situation, with the religious groups that are pressing and have a growing political power, it's hard to predict. Although I would suggest that it would be 5-4 against any exemption under the executive order.
I see. It's going to be interesting to watch. As mentioned, the justices tried to keep that Hobby Lobby ruling as narrow as possible, as they frequently do with these landmark rulings. But of course, the narrowness still has to be decided in the courts, and it will be put to the test there. Once again, that was Richard Cohen of Rothschild. To read more of his insight on this executive order and other issues in the employment discrimination space, be sure to visit his blog. It is at employmentdiscrimination.foxrothschild.com.